My name is Don Lawrence. I am an attorney here in Scottsdale, Arizona. I've been practicing since 1997. I am a partner with Mueller, Drury, and Lawrence, and we deal exclusively with homeowner loss mitigation issues, modifications, negotiating short sales, second lien settlements, foreclosure defense, or just about anything else trying to keep people in their homes and keep families together. Arizona is a trustee sale state. Most of these people are hearing the news accounts of robo-signing scandals and cases in New York and Maryland and Kansas where homeowners have sued their lender or their servicer, or they've been in bankruptcy and done that and gotten their home free and clear, which that has happened maybe once or twice, maybe 3 times out of hundreds of thousands of cases. But they've gotten wind of those because those are the cases that make the news.
That's right, Bill. If you can't prove you hold the mortgage, you can't foreclose on the property.
They don't understand that most of those cases take place in judicial foreclosure states where the lender or the servicer has to file an actual legal action against you to foreclose on you. Here in Arizona, we're trustee sale. All they have to do is properly follow the statutes for notifying you and the deed of trust for notifying you of that trustee sale. And that's pretty much all they need to do. And in most cases, the judges are looking at this and essentially saying, you borrowed the money from somebody, and we're not going to necessarily make the party over here prove up title. And in some cases, they have been successful, the homeowners, but they're spending tens of thousands of dollars to do this. And in my question is always, what's the ultimate goal here? I mean, if the ultimate goal is for you to get your home outright and not have to pay anything, I'm the wrong guy to see. I'm somebody who, the way that we approach this is very practical. We want to help you stay in your home for the least amount of money that they have to pay. Everybody who walks through our doors are in financial distress. And so we're trying to help the process and keep people in their homes because in these litigation cases, really the only people who really benefit are the attorneys who get their fees. I'm not aware of any case in Arizona where a homeowner has successfully been able to argue that the servicer and or lender who they are paying does not have the legal right to take that payment and had their mortgage or their deed of trust and promissory note extinguished by a judge. It just doesn't happen. Well, a quiet title action is simply one that is determining who is the rightful owner of the property. The foreclosure defense that we do typically is someone who was in the modification process, who were assured that a trustee sale was not going to happen while they were in the modification process, and it did happen. And so now these folks are coming to us saying, hey, help us. And so we sue the bank really for the intention of getting the home just put back in the homeowner's name and following through with the modification process. Because 9 times out of 10, the lender or the servicer will admit that this really shouldn't have happened. The foreclosure department wasn't talking to the loss mitigation department, or somebody didn't hit the right code or something like that. And so we get back into the modification process, assuming that as we've done our work at the beginning, we believe that the client is modifiable. If a person comes to me and they're not modifiable, then I don't really think that they should spend the money trying to fight the bank, because there's nothing there for them. Where that came out of was just these law firms and organizations that were churning foreclosures, and for efficiency's sake, and most of these cases happened in judicial foreclosure states. The servicer or whoever was foreclosing had to submit an affidavit stating that someone in that organization was aware that there was a valid note, that they were the rightful party, and that they had standing to foreclose. And those affidavits were being done using people's names who either didn't exist or didn't actually have specific knowledge of those things, or they were notarized in a way that was a violation of state law. And all of those things are serious issues, but they don't really go to the fact that if you weren't making your payments, then you defaulted on your loan, and maybe this foreclosure shouldn't have happened, but that doesn't mean that once they fix things, that you're not going to get foreclosed on. The whole robo-signing issue doesn't provide any finality to fixing the issue of, do you get to stay in your home? It's just another red herring or another thing that people are preying on to victimize homeowners once again. And ultimately what I mean by that is taking money from them and giving them hope that something is going to work to invalidate this mortgage or attack the lender for fraud or a TILA violation or a RESPA violation or a state law origination violation when Bank of America or Wells Fargo or Citibank didn't, in most cases, originate those loans. They weren't the parties who, if there was fraud, committed fraud. And that's why so many of these things are getting kicked out, because homeowners just don't really understand the legalities of how you establish these cases and what is really a valid legal argument in court. If it has been successful, it just simply makes them go back and do what they're supposed to do, the servicer and the lender. Well, anytime anyone brings an audit into me for the consultation, first of all, I'm suspect about who they've been talking to, but secondly, I don't put a whole lot of stock in that. I mean, the only time that I'm going to do an audit is if for some reason it's needed or necessary in the litigation that we do, and I can tell you that we've done, probably over the last 4 years, about 20 cases, and we've never had to do one. In HAMP, there is a provision that states that once you are in the modification process, all foreclosure activity is to cease, and a trustee sale is not to happen, okay? So let's say it does happen, which it does all the time, while you're in the modification process. Home forecloses, you're told you gotta be out in a week, and then the next day the modification company or the modification department still calls you and tells you that they still need pay stubs, and you're trying to figure out why this is happening. We had a case where we believe there was a wrongful foreclosure. We sued under what's called third-party beneficiary rights. And what that means is that the Treasury Department contracted with Bank of America as a part of TARP in giving them TARP money to prop them up and allow them to continue to exist. They said, you have to do HAMP, and that's a prerequisite. So we've got this contract, right, these terms. The parties are the Treasury Department and Bank of America, not you, Mr. Homeowner, unless it's very clear in the contract itself that this was intended to specifically benefit a particular third party, which I still believe that it's very clear that that was intended to benefit homeowners to keep them from going through foreclosure. The problem is in Arizona, most of the federal judges have said no, it does not extend. There have been some decent cases in the Southern District of California where they've said that it does, and that all that means is that if you are a third-party beneficiary, you have the right to sue for breach of certain terms of that contract between the other two entities. But we've not, unfortunately, we've not been successful in that line here in Arizona. There's only two ways that we have seen any success in that, and that is either a modification or a Chapter 13 bankruptcy. And a Chapter 13 bankruptcy prior to modifications, which prior to 4 years ago, nobody modified their loan. You didn't even know what that meant. If you needed to stay in your home, you went into a Chapter 13 bankruptcy that was specifically put together to allow you to pay the arrears that you owe over time while you're making your normal payment. And at the end of the bankruptcy, you've paid all of your arrears, you've continued to be current, you come out of the bankruptcy current. It provides permanent payment relief. That's the point. And so there's no other way that I'm aware of to do it that you can have any level of confidence that it's going to happen. Those are the only two ways. Absolutely. The process is much more streamlined. We have a level of expectation as to what we can do. Our staff, we're fortunate that in the 4 years that we've been in business, we've had very little turnover. So our people have been with us. They know the process. They know how to really just hold the servicers accountable and drive the file forward, understanding that there are going to be mistakes on the other side. If you get a decline, it doesn't mean the end. We just have to assess why it was declined, what documentation and information were they using, was it correct? Because in most cases, before we even submit, we know whether you should be modified or not, and we should be within dollars of what that payment should be, as long as there's no additional surprises. Well, and they hear the horror stories, or maybe they've even tried to modify before, and they got frustrated because they kept being asked to send in the exact same information over and over again. They got all sorts of bad information. Their neighbor down the street said it's not possible, these things aren't real, it never happens. There's all sorts of reasons why not to call. But ultimately, if you want to try to stay in your house, if you're not making your payment, there's only so much time before the issue becomes acute and you have to deal with either getting out or making another hard decision. We have short sale negotiation that we do, and that's a whole nother side of exposure to folks, because Arizona is a unique state and has really good anti-deficiency laws. And what that means is that as long as you're in a qualified property, to be in a qualified property, it's got to be 2.5 acres or less. The lot is 2.5 acres or less. It's a single family residence or duplex. And the loans that we're talking about after the foreclosure, those loans were used to buy the property. Okay, so if those three are in place, then the bank doesn't have the ability to sue you after a trustee sale. But many cases, you've got people who get seconds after they've bought the property, so they have exposure on those seconds. And so it's important to understand what your exposure is. What people don't often understand is that in a short sale process, the anti-deficiency laws don't apply. So even if both of your loans were purchase money loans, in the short sale process, if they don't get waiver language in the approval where the servicer or the lender agrees to waive any deficiency rights, then that lender has 6 years that they can come back and sue them. And they are doing that. And we see that happening all the time, especially where realtors are negotiating.
Even the wrong words seem to rhyme. And out of the doubt that fills your
Probably the biggest one that we see is people don't understand that who they're sending their money to doesn't own the loan in most cases. And they're trying to figure out, why wouldn't this organization want to work with me if they're going to take the hit? The foreclosure is going to be a financial hit to the institution, so why wouldn't they want to work with me? Well, part of that is because in most cases you're dealing with a servicer. A servicer is just like a property manager. If you've ever rented houses, they're just collecting money and passing it on to the entity that actually owns the asset. And there's a contract called a pooling and servicing agreement that dictates how they are to treat that particular loan, what loss mitigation or modification options are available, how they deal with a foreclosure process, and so they have the dictates that they have to work within. But in most cases too, a servicer earns more money from you in default than they do with you being current, because they keep all the late fees, they keep all the ancillary fees, the home inspection fees, and all of those things. And who actually owns the note pays those things once everything is done. So at the beginning of the process, there was somewhat of a lack of incentive on the part of the servicers to ramp this up. But now that this has kind of evolved and this has matured, we've gotten to the place where I believe most of these servicers have non-performing pools of loans that they know that they have to get these things modified and get them performing again, so that they stop taking the losses and stop pushing those losses on down the road. Eventually they're going to have to realize them and be accountable to their shareholders, on top of being accountable to the Treasury if it's a TARP issue or whatever else. So. Well, it's funny because we have clients, we see people all the time who haven't made a mortgage payment in 2-3 years in some cases. And the problem with them, and what we really try to make them understand, is you need to start, this is what we believe your payment is going to be. You need to start putting that money aside now, because you need to get back in the habit of making a mortgage payment, because they've been consuming that money. If we believe they're modifiable, it means that they have income, it's consistent, and so now they need to start getting back in the habit of making that payment. And in most cases they should be putting it in the bank or something like that, just so that they're ready when it's time to make the trial payments. They can do that.
foolish child, I'm feeling like a foolish child. Where have you gone? Oh, the paper man won't leave us alone. And
The key in any short sale situation is they need to But before they do anything, they need to get good, sound legal advice as to what their real exposure in that transaction is. Because the realtor's not going to tell them. So they need to go see an attorney to determine what their exposure as far as any deficiency issue is. And there could be tax issues as well, depending on if you're selling your primary residence or an investment property or a second home. There are tax issues that could happen. The protections that are there on an anti-deficiency basis are only there in a trustee sale scenario. They do not apply in a short sale scenario. So even if you have two loans that were both used to purchase the property when you bought that property, if you short sell, you could be exposed to a deficiency legal action, and the lender or servicer has 6 years. That's the statute of limitations, 6 years. So they're not in any rush. They have plenty of time to determine whether they're going to come back and sue you or not. And so the key in any short sale situation is getting waiver or non-deficiency language in that approval letter. Because if we can't get that release language and you would otherwise be protected in a trustee sale, we're going to tell you to let the property go so that you will be protected. And that's what's, I think, most important, is that people get the kind of advice that protects them and their family. I would not recommend buying anything before that. If you're dealing with a decent attorney who understands this area of the law, that's absolutely right. And then the attorney will tell you what you need. And I can tell you that in close to 300 permanent modifications that we've done in the last 3 years, we've never needed a forensic audit to get that done.
One day I was out walking.
We give a free consultation. It usually lasts about 45 minutes. We review everything involving their loan. So we're talking to them about what their anti-deficiency issues are. Do they have exposure? What their financial situation is? Do they qualify for a modification? One of the first questions I always ask is, ultimately, what do you want to do? Do you want to keep the property, or do you want to get rid of the property? Because we've got two different tracks that we can go here, and we've got two different strategies, and strategies within each one of those. And oftentimes people don't know. So that's something else that's real important to us, is that we don't judge whether you should stay in that property or not. There are plenty of people out there that tell you it's stupid. Why are you in a property? You're $200,000 underwater. Why stay? Well, there's a lot more that goes into being in a home that doesn't have anything to do with the value of that property. Are you in a good neighborhood? Do you like the schools? Do you like your neighbors? Are your kids happy? Are you happy there? So what is it that you value the most? And then based on that, we find the strategy to help you accomplish that, and determine whether or not you have the circumstances that will allow you to accomplish that. If you're not modifiable, if you're not making enough money to do a modification, we're going to start talking about what other options there are, and short sale is one of those options. Our hope is that at the least, the people are walking away with enough information that they can stop the anxiety attacks or stop the sleepless nights. Now they know that somebody's not going to come banging on their door and tell them to get out of the property tomorrow when they haven't even been noticed a trustee sale yet. From the point that they notice a trustee sale, it's 90 days. So there's plenty of time to do things, but it's better to start sooner than later. It's better to know what your options are so that you can begin to plan for them and determine which road you want to go down. And it's better to be doing that earlier rather than us or someone else having to try to deal with postponing a trustee sale or looking at having to file a bankruptcy if we have to keep that from happening. We will tell people whether there is a chance to save anything or not. And the one thing for us is that we want them leaving so that they are positioned to not get taken advantage of, and to be able to understand, this is what I'm looking at, this is the reality of my situation, and I need to make a plan. And that happens. We turn people away because if they're not modifiable, it doesn't do us any good to take their money, and if we don't believe that we can fix their situation. Yeah, it's tremendously fulfilling. That's why we've done it for so long, and it feels good to be able to do that and keep people in their homes.